Before we dive into legal research, let us first have an overview of the Philippine legal system. The Philippine legal system has three goals. First, to promote peace and order in the country. Second, to practice mutual respect among the different branches of government, namely the executive, the legislative, and the judiciary. And third, to have check and balance among these different branches. This is to ensure that there is no excess in the wielding of power in any of the government authority. Now let's go to the classification of laws by authority. The highest and supreme law of the land is the Constitution, which is ordained and promulgated by the sovereign Filipino people. This is then followed by the primary laws sourced from the different branches of government. From the legislative department, we have statutes such as Republic Acts or Commonwealth Acts enacted by the said department. From the executive department, as they execute the laws enacted by the legislative department, it also has the power to execute or issue administrative orders or proclamations, and these are what we call executive issuances. The judiciary, on the other hand, interprets the laws whenever there are conflicts, and these interpretations can be found in its judicial decisions or what we call jurisprudence or case laws. As these different branches of government check and balance each other, the legislative department may conduct hearings in aid of legislations over the executive department, while the executive department has the veto power through its president over the bills from the legislative department. And the judiciary has the power to decide on appeals or petition for certiorari wherein the issues pertain on the interpretation of laws. Now, what if the law is silent, obscure, or insufficient? What will the judge do in that particular case? Well, in that instance, the judge may refer to what we call secondary sources, which are as follows. First, we have customs not contrary to law. Second, decisions of foreign and local courts on similar cases. Third, opinions of highly qualified writers. Fourth, rules of statutory construction. Fifth, principles laid down in analogous instances. And last but not the least, natural moral law and equity. Remember that all these secondary sources have persuasive effect, so the judge may use any of these whenever the law is silent, obscure, or insufficient. Now that you know the basic of the Philippine legal system, the challenge for you as law students is to exert your utmost effort in having a good foundation of the laws. And even after you become lawyers someday, you must continue your legal education in order to effectively help in attaining the goals of the Philippine legal system. Thank you.